Hey guys, there were two recent policy changes that were published on the USCIS website, and I want to just generally discuss what these changes are and how they could affect people who are applying for certain immigration benefits. The first one was regarding USCIS's use of derogatory information. This basically created a couple changes to the USCIS policy manual that clarified when they intend to share that they're using derogatory information to deny an application. For example, let's say you're applying for permanent residence and USCIS has some bit of info that they can't really share with you. Like, for example, they believe you lied somewhere along the process with a different government agency, and due to that information either being classified or limits on the information sharing ability between agencies, they can't disclose to you exactly what that information is. But they believe it's enough information to deny your application, for example. What they will do is request that information directly from you, either with a request for evidence or a notice of intent to deny, to see how you respond. And then they'll use your own information against you to deny the application. I'm curious to see how they would react if the information you provide is different than the confidential information they have, since they're not able to disclose that information. It just clarifies and creates a new way for USCIS to deny benefits by using derogatory information against specific applicants for immigration benefits. The second main policy change was regarding the N648. So this is something you would file with your N400, your naturalization application, if you are seeking an exemption, a medical exemption based on a disability. So you don't want to take the civics test, or you don't speak English and you're very disabled and your disability prevents you from learning English or learning new information for the civics test, you can file the N648, which basically requires a physician to explain exactly what your disability is and how it impacts your ability to meet the requirements for the N400, and if USCIS approves it, they can allow you to naturalize without taking the civics test or speaking English, or you can, those are the extreme ends of it. You could also seek different accommodations along the way that fall short of full exemptions. USCIS has noticed, and this is definitely true, I've seen this happen, I mean, not with my cases, but anecdotally, some people engage in fraud throughout the process where, they find a physician who's just willing to certify that they're not able to learn the test information, and it doesn't really meet the requirements. Like, I've done a couple of these N648s in my career, not that many, but probably fewer than 5. And every time I did it, we had to provide an extraordinary amount of information to prove that the applicant is not able to take the civics test, or they're not able to learn new information. Like, I remember a specific case for this 89-year-old woman who couldn't speak English. She was a Spanish speaker, and she was undergoing chemotherapy, and her brain had rotted away, and she literally couldn't learn new information, both because of dementia and the chemotherapy and just age-related memory loss. So each one of these by themselves might not have been enough in this specific case to get the N648 approved. But the combination of factors really made it so it was literally impossible for her to learn new information. And we had to go to USCIS for an N400 interview 3 times. And all 3 times, the USCIS officer asked for more information and really put us under the microscope and made it really difficult, way more difficult than I actually thought it was going to be. And then finally, on the ultimate time, the supervisor was there, he approved it, and right then and there, he swore her in and she became a citizen. So this example I'm giving was under Obama. So perhaps we're going back to that standard of rigidity where things are looked at under that much scrutiny. But generally speaking, what this memo does is it creates a higher burden for physicians to prove that the disability, the claimed disability, directly causes the applicant's inability to learn the information for the civics test or to learn English. In summary, this just makes it a little bit harder for the average applicant to seek an exemption from the N400 requirements based on disability. If you want to stay up to date on all of USCIS's policy updates, be sure to subscribe to my channel. I'm an immigration lawyer based in New York. I handle cases nationwide. If you personally need any assistance with family-based immigration, naturalization, or immigration court proceedings, contact me. You can find my information in the video description below, and I'll see you guys next time for another video.